Good afternoon and greetings from Peshawar. I welcome you to the discussion on Afghanistan under the lens of international law, organized by CLLB in collaboration with Institute of Regional Studies, Islamabad. 82.4 million people worldwide were forcibly displaced at the end of 2020 as a result of violence, conflict, persecution, and events seriously disturbing public peace. Out of 82.4 million, 26.4 are refugees. 68% of the number is contributed only by 5 countries around the world, and Afghanistan is one of them. The United Nations Convention on the Status of the Refugees 1951 and its additional protocol of 1967 provides a legal framework to manage refugees around the world. Today, we will be talking about Afghanistan, the refugee situation, past and present. My name is Dilawar Khan. I'm the Executive Director at the CLLB. Let me introduce you our today's guest. We have Barrister Ibrahim Afridi, who is a practicing lawyer and based in Peshawar. We have Barrister Shah, who is a practicing lawyer based in Peshawar. We have Barrister Sarwar Muzaffar Shah, who is also a practicing lawyer and based in Peshawar. They all are faculty of the CLLB. I'm very happy hosting you today for today's discussion. Let me come first to you, Barrister Ibrahim. Voluntary repatriation remains a preferred option for the hosting states. What do you think, where is the principle of non-refoulement in the present world politics and where it should be legally?
First of all, I'd like to thank you for this lovely opportunity. And with regards to this question, the focus is first on the person of concern. And with regards to that, the whole system needs to revolve around the pull factors. The country of origin has to be at a position where the pull factors of these very persons of concern want to voluntarily go back. The concept of non-refoulement basically makes it an obligation for such host nations to have such an environment where these very persons of concern could go back. But when we talk about these pull factors of the country of origin, we have to accept that there is a need for the international community to come into play and make sure that that very nation has the requisite pull factors that allows for such person of concern to want to go. Now, what could be those pull factors? First of all, security. The foremost reason for someone to go back to their very country of origin is if they feel safe to do so. Because the very reason for them being in the situation they are is because there's a concern for their very own security. Apart from that, what is most important is that what steps can be taken further. With regards to that, I would like to talk about RAHA. RAHA, to the extent of, it's basically the Refugee Affected Hosting Areas 2005. Pakistan is one of the biggest recipients of RAHA. Now, what this does is there is always a fatigue with regards to the hosting nation. What could be those fatigue? The economic and administrative pressure. Now, how can this be tackled? That is where situations like RAHA come into place, which allow the host nation to facilitate the persons of concern. In doing so, not only are the persons of concern being looked after, but the host nation itself is being able to work and focus on their infrastructure. The second aspect is with regards to a need. It is, even though Pakistan is not a signatory to many of the conventions and its protocols, but there is an international precedent where human rights are looked at a certain perception. Having said that, there is a need for adoption. There's a need for a concern to be recognized. So with that said, there have to be steps taken when the persons of concern first came in 1979, they were not, I would say, administratively, the capacity of Pakistan, as an example, wasn't as it is now. There are basically cards, smart cards being allotted, which can help data being taken into account. And in these ways, the host nation is at a better place to accommodate such persons of concern.
Barrister Syed Mohammad Shah, most recently, some statements were made by the Pakistan Foreign Minister and the National Security Division in September 2021. How you legally measure the reluctance to intake more Afghan refugees?
There is the 1951 Convention relating to the status of refugees, and there is the 1967 Protocol, which expanded the application of the 1951 Convention. Both of these are the cornerstones and the only global foundationary legal instruments that provide any legal cover to refugees. Unfortunately, Pakistan is not a signatory to either the Convention of 1951, and nor is it a signatory to the 1951 Protocol. And it is in the Convention and in the Protocol that the principle of refoulement has been established. And that principle basically prevents, that principle states that no country is to prevent a refugee from entering its territory, and no country is supposed to, by force, expel a refugee back to a place where they've come from, where they're insecure. So the principle of refoulement was established in the 1951 Convention and the 61 Protocol, to which Pakistan is not a signatory. However, that should not be an obstacle, because Pakistan at the same time is also a signatory to the Universal Declaration of Human Rights, which we ratified in 1948. In the UDHR, Article 14, I believe, states that refoulement is prohibited. And there is no exception to it, if I'm not mistaken. We are also signatories, and we've also ratified the Convention Against Torture, which I believe is Article 3 thereof states that refoulement is again forbidden, where you cannot send somebody back to where they've come from, nor can you prevent them from coming.
Okay. Barrister Sarwar, taking the question further on the same lines, how would you see the UNHCR warning that Pakistan might face another influx of Afghan refugees by December 2021? And as clearly indicated by Barrister Shah, that in the absence of national refugee legislation, non-signatory to the international instruments such as the 1967 Protocol and the 1951 Convention, how you think Pakistan may plan a better management strategy? And does Pakistan has any specific laws which deals with the plight of the refugees?
Dilawar, you have two parts of your question. One is management, the management part. The other is the law. You need to have domestic law to better manage any plan. Though my friends have said Pakistan is, and rightly said, Pakistan is not signatory to the 1951 Convention, and it's not signatory to the 1967 Protocol. However, Pakistan still has obligations, it still has laws, and they're divided in two parts. The first is the domestic law. Yes, we do not have any legislation or an act of parliament passed specifically. It's slightly ironic, though we've been dealing with this crisis for the last 42 years. But our constitution, I believe, provides a better framework, a good framework, a substantial framework. In our constitution, Chapter 2, fundamental rights and public policy are the ones pertinent here. If we read Article 40 of the Chapter 2, it's about public policy. And Article 40 says it's state's obligation to strengthen bonds with the Muslim country and promote international peace and security. For Pakistan to play its part in international peace and security, it has to act. It has to play its part in managing the refugee crisis, which is one of the longest protracted refugee crises, the Afghan refugees crisis. However, if we look at Article 29 of our Constitution, same Chapter 2, it says, insofar as observance of any particular principle of policy may be dependent upon the resources. Now, as you mentioned, the influx is huge. This particular Article 29 caters for it, that the influx is huge, our resources might not be able to cater for all of them. So it has the framework. Now we go whether these refugees, in the absence of particular legislation, has rights. They do. The important right is Article 4. What it says? It says to enjoy protection of law and to be treated in accordance with law is the inalienable right of every citizen, wherever he may be, or every other person for the time being within Pakistan. What I like to highlight here is the Constitution has used the words every citizen and person. So it doesn't mean if a human being is not a citizen of Pakistan, the Constitution doesn't apply. It does. I believe our Constitution provides adequate protection. This was the domestic law. Now, our obligation under international law. Our friends have already mentioned the United Nations Declaration of Human Rights. My friend Mohammed Shah has pointed towards International Covenant on Civil and Political Rights. He also mentioned International Covenant on Economic, Social, and Cultural Rights. He also mentioned the International Convention on Child Rights and International Convention against Torture. These all, where they stem from? They stem from the Universal Declaration of Human Rights. Now, we've ratified Universal Declaration of Human Rights. We have signed and ratified both the covenants, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights. We might not be signatory to others, but what this shows is that these human rights instruments and the regional ones, for example, the European Convention on Human Rights, the African Charter, the American Convention on Human Rights, they have all used or they have codified according to the Universal Declaration of Human Rights. What does that mean under international law? It means that it has become customary international law. So Pakistan is also obligated under customary international law to cater for these things.
Thank you very much. Very detailed observation on the domestic legislation, what the domestic legislation clearly defines as the rights of the persons. Barrister Ibrahim, what Barrister Sarwar has mentioned, very detailed analysis of the national legislation, but he also pointed towards the absence of national refugee legislation. What are Pakistan's legal options to determine the status of Afghan refugees in the absence of national refugee legislation?
First of all, there is a need to accept the management of these persons in concern. 67% of these very persons of concern are now settled in urban areas. The next step is to see what the current legal framework is available to them and to Pakistan. Barrister Sarwar rightly mentioned the need for using the Constitution and other areas which I will mention to put together a codified framework. Section 4 of the Citizens Act 1951 clearly states that any person born in Pakistan shall be a Pakistani national. Through this, many of these very persons of concern have married men from Pakistan who have then taken the nationality of Pakistan. But the same way, the women of Pakistan who married Afghan nationals are facing hurdles and issues. Now, there is a need for legislation. And the reason for this is that the courts in Pakistan have looked at the nationality issue. But because there's not a codified framework, the interpretation that they have taken is not in line with the international standards. It is a prerequisite for the government of Pakistan to put together a legislation which is at par as per the standards internationally in order to prove that it's a responsible member of the international community. By doing so, the role that is needed by Pakistan as a host nation will not only be fulfilled, but the obligations as per the standards set by the international community will also be implemented. And the courts will be able to implement and interpret through that very codified framework to help put together what the current status is. We have taken the right step with regards to digital data, with regards to the smart cards, but we have to take it further. There has to be a framework which can be relied upon.
Barrister Shah, what are some of the key challenges for UNHCR regarding to the enforcement of refugee law under the individual complaint mechanism?
The UNHCR is known as the guardian of the International Conventions on Refugee Law, the 1951 Convention and the 1967 Protocol. And under Part 8 of the said statute, it has a supervisory role. And it only has a supervisory role. It supervises the application of the Convention of 1951 and the Protocol of 1967. And although it is merely a supervisory role, there are also then corresponding obligations upon states, contracting states, mind you. So states that are parties to the 1951 Convention, and as well as states who are parties to the 67 Protocol, are under a legal obligation, because these documents are binding as it is, and they're also under a legal obligation to cooperate with the UNHCR in terms of the application and the facilitation of the refugee conventions. Now, of course, one of the challenges is, as I mentioned, that UNHCR only has supervisory roles, but they can be quite persuasive and influential, no matter. Furthermore, the states, contracting states, are obligated to reciprocate and to assist them and to facilitate the UNHCR. The other main key challenge is that the UNHCR does not have a corresponding court nor a committee to enforce the refugee law. See, states are sovereign in nature and they cannot as such be compelled to follow by force international conventions. They can obviously attract the ire of the international community, but they cannot be forced as such. So as I mentioned, there is no corresponding court or committee that can assist the UNHCR in the implementation of the conventions. Finally, what about those states that are not contracting parties to either the convention or the protocol? Now, it may seem that we are entering into muddy waters here. However, states that are not contracting parties, even they are obligated per customary international law to cooperate with the UNHCR. How is that? Now, if we look at the statute that I mentioned, the statute through which the UNHCR was established, Resolution 428, I believe, Resolution 4285, it calls upon governments. It calls upon governments, not contracting/non-contracting parties. It calls upon governments to assist and to facilitate the UNHCR in its role as a supervisory body.
Okay. Barrister Sarwar, we have covered the need for national refugee legislation, the mandate of UNHCR, and the broader international community. How do you see the prolonged stay of Afghan refugees in Pakistan? What legal challenges do you consider are important to be considered while designing any future management policy?
I'll have to go into a perspective for a bit, because we keep asking Pakistan, since my friends said it's the neighboring country, and asking them to do more. Naturally, they have to do more because they are the neighboring country of Afghanistan. But what have they done in the last 42 years? It started in 1979, when the Afghan war started. When the Afghan war started, in the first year, we received, according to the reports, international reports, about 1 million refugees. By 1981, it ballooned to 2 million refugees. According to the statistics, by 1990, it increased to 3.2 million refugees. And that not to mention the undocumented ones. Now, by the way, we all are from this region. We live in Peshawar or the surrounding areas. We've lived with these refugees. We know what they went through. We know how much rights they have. I studied at Edwards College. I believe some of our friends have. They were ones with us. They were not citizens, but they were with us in Edwards College. They were with us in the universities. Those of us who studied at Pakistani universities, they were with us. Now, for 42 years, bearing the brunt which the international community is supposed to be sharing, we've dealt with that. Even the rights I've mentioned earlier in answer to my first question, the rights, for example, they have family rights. They have married into Pakistani families. They have married men, and they have married women. They have established businesses. I was told by a learned man, a very informed man, that 95% of the honey industry is controlled by Afghans in Pakistan. They came, they brought their carpet making skills. Carpet industry in Pakistan wouldn't because of them. So they have businesses. They own property, sometimes through proxies, but they own properties in Pakistan. Now, Pakistan they have freedom of movement. They can go from Peshawar to Karachi without any hesitation, without they showing their cards. Sometimes they do. If you challenge the law, sometimes you have to. Even we have to show our NICs when we travel, at every checkpost, by the way. But now, Pakistan has done its fair share. I'm not saying Pakistan should not do more in terms of legislation, in terms of accepting them more. But the international community need to step in, and they need to do more.
The key takeaway from today's discussion is that it is not only the responsibility of the hosting countries, but under the shared responsibility principles of international law, every state and every institution is responsible for the welfare of the refugees world over. Thank you very much.